Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Brandy Thompson from the Kronzig Firm, and Mary Chartier from Chartier Nyam Fukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people and real legal problems.
In the name of CPS Defense and Family Law.
The last time we were together, we talked about getting an initial custody order and what that process looks like. And I'm here again today with Chuck Kronzig. He is an attorney and partner at the Kronzig Law Firm and has been practicing family law for 26 years. We're glad to have you back, Chuck. There's a lot more to talk about.
There's plenty to talk about.
So one of the things we didn't get to was talking about parenting time and how that fits in with that initial interim custody order.
Yeah. So once the friend of the court and the judge make a determination about what's going to happen with custody, at least on an interim basis, the next thing they've got to figure out is parenting time. Which parent will parent the children at any given time? And that's a little bit of a process too. Sometimes it begins with an agreement of the parties, mostly not. Other times it begins with what's practical. When is a parent available to parent the children? If one parent works all the time and the other one's at home, of course, that's going to dictate what's going on. Sometimes both parents are working. Sometimes they're working opposite shifts. But they begin with who can parent the children when they're available. From there, the friend of the court, the judge, the courts will do whatever's in the child's best interest. There is a presumption built into our statutes that having a close and continuing relationship with each parent is the right of the child. And although our statutes talk about the rights of the children and the rights of the parents, courts seldom pay any attention to the rights of the parents, and almost everything we see in the world of family law is focused on the best interest of the children. So the overriding concern in parenting time orders is what's best for children, and courts determine that not only by an examination of the best interest factors, those 12 factors we talked about in the last episode, but here the courts are given 9 additional factors that they can consider. Interesting to note that when we're talking about custody, consideration of 12 factors is mandatory. And when we're talking about parenting time, the consideration is optional for courts for those 9 factors.
So how often is it, well, let me put it this way. Is it normal for parents to have 50-50 parenting time where the schedules are evenly split, either week on, week off, or some other schedule that gives them the same amount of parenting time?
Well, I think that varies county to county and how you would define the word normal. If someone requests a different parenting time order, the courts will certainly look at that. So I don't know that we call it normal, and I don't even know that I'd say it happens in the majority of cases.
So let's talk about what happens after the parents received their recommendation from the friend of court, which becomes an order of the court on the interim basis. What do they do if they don't like what the referee said?
Well, the most important thing to do is follow the order. At that point, your attorney can object to the order. And again, there's a process for objecting, but at the end of the day, you are entitled to something that is called a de novo hearing. It means from new or from fresh, which would give you the idea that maybe you get another bite at the apple when this case is sent over from the friend of the court referee to the judge.
But you and I both know that doesn't happen usually that way. From a standpoint of judicial economy, the judges don't want to hear everything again that has already been presented to the referee. So in your experience, what's the typical process for this quote unquote de novo hearing?
Yeah. So the process begins with preparation of a transcript of the hearing before the referee. That alone is sometimes a deterrent to a parent asking the judge to review the case, because those transcripts can cost hundreds and hundreds of dollars, and not everybody can afford to spend hundreds of dollars on a transcript. But nonetheless, that's the first step usually. And I say usually because there are a few judges around that don't request those. But the transcripts are prepared, and then the judge reviews the transcripts prior to the next hearing. Most judges will then allow testimony from the parties, but not additional testimony about things that happened or could have happened back at the time of the referee hearing. So if there have been some things that have happened after the referee hearing, most judges will hear about those. But if you had the opportunity to present testimony or witnesses or evidence back at the referee hearing, the judge is not going to let you go back and do that all over again.
Right. So then the judge takes that same process of applying the statutes about the established custodial environment in the best interest to make a decision again? Or is the judge really just saying, I agree or don't agree with what the referee said?
No, they've got to make specific findings on each of the 12 factors. That does not mean they can't agree with the friend of the court, because sometimes they do. And in fact, a surprisingly common occurrence is for them to agree all the way around. Most of our referees have a lot of experience. They do a fine job, and they, more importantly, they understand how their particular judge operates, how they think on particular cases, and the referees kind of skew their decisions in a way that they believe the judges will adopt. So yes, the judges do find specifically on each factor. They determine how heavily or not they will weigh each factor, and that's how they come up with their decision.
Can we talk for a minute about one of the 12 factors is the child's reasonable preference? Can you touch on that?
Sure. Our courts have said that a child's reasonable preference is not alone sufficient for the court to make a decision, but one of the factors is the reasonable preference of the child, if the child is of sufficient age and maturity to give an opinion. So from the onset, the judge first has to determine if we're dealing with a very young child, a toddler perhaps, maybe the judge is less likely to put a lot of weight on what a toddler says. Teenagers are very different, though I've seen certain judges totally disregard what a teenager says. The judges usually find this information by interviewing the children privately in their offices, and the courts have held that the topic in the office, the private interview, is limited to the reasonable preference of the child. Interestingly, the courts have also said that if there's a desire to expand a discussion with the child beyond their reasonable preference, that has to be done in the courtroom on the witness stand. No judge that I've come in front of likes to put a kid on the witness stand.
Can we touch on some problem areas that come up?
Yeah, there's lots of problem areas that occur during parenting time, and as hard as we try to avoid them and coach our clients to avoid them, they come up. One of the common things that happens is parents not showing up on time, or not showing up at all. Suffice to say that as much as one parent might want to play games with the other parent or sabotage it, truth of the matter is you're playing games with a child and you're sabotaging the child. When a kid expects the opportunity to spend time with their parent, they don't understand the acrimony that happens in a custody dispute or in a divorce case. So we try to avoid that sort of thing at all costs. Other things that happen at parenting time exchanges are nasty encounters, yelling, screaming, bringing other people along, standing there with a video camera, recording the actual exchanges. And the list goes on and on and on. You forgot to send her homework. He didn't bring his soccer uniform because he's got practice this afternoon. it's just never ending, and we're always surprised at something new that's come along.
Well, thank you.
In the Name of CPS Defense and Family Law is brought to you by the Kronzek firm. In the Name of Personal Injury Law.
We often have Steve Sinus of the Sinus Stramus Law Firm to talk to us about various aspects of personal injury law. But today, Steve has with him a very special guest. Steve, did you want to introduce your guest?
Yeah, it's great to be here. It's even better to be here with a special guest. He's a man by the name of Steve Whalen. I have the honor of having been his attorney in relation to serious injuries he and his wife Sally sustained in a motor vehicle crash that occurred in October of 2015. And he's been so kind to come on the show today to share with us some of his experiences regarding this crash, just to give the viewers some insights about what it's really like to be in a crash and the realities people face. So I just want to thank Steve for being here. It's so great to have you, Steve.
Thank you. So just to tell a bit of the story, October of 2015 was a gorgeous sunny day. We were going to go to Grand Rapids from East Lansing to go to a musical, and grabbed the keys, got out of the car, driving on Highway 96, and then noticing the beautiful fall leaves. And then I noticed a vehicle that was coming across the center median at us at a very high rate of speed. See, as a job, I'm a police officer, and part of my job is I work on the fatal accident reconstruction team of my county. And I pictured right away what was going to happen in this crash. So I hit the brakes as hard as I could. We collided. The driver coming at us was going 90 miles an hour. We were going 70. It was a horrific crash, horrific explosion. Immediately, airbags, everything went off. And then I am in the car wondering what's happening. I lean over to my wife. I say, Sally, Sally, and she has no response at first. And then within a few seconds, she said, Steve, it hurts. And I thought, well, I was just so thankful to God because, number one, she knew my name, which means she had cognitive ability and she was alive. Right away, we kind of jumped into my training mode, and somebody came up to the car. I knew that we were pinned in the car because it was destroyed all around us. And this person asked, what can we do for you? And I said that please make sure they know that the 911 knows that we need the jaws of life, and that we need a lot of help. And I also asked them the condition of the other driver right there. And he left and then came back and said the other driver had passed away. So it's very, very dramatic. In the car, trapped in there, I then found my phone and called all my kids and had to give them incredible news that we were in this horrific accident. My wife was having a difficult time breathing, but we ended up having great response from the paramedics and the firefighters and the police officers. And then we found ourselves in ambulances heading to Sparrow Hospital.
And Steve, you're such a respected member of our community, and your experiences investigating crashes obviously plays into the perspective you have here today. But I think one thing that what you've told me in the past about this particular crash is that here's where a crash that occurred where you were actually injured, and you and Sally were injured. And can you explain to the viewers what that was like for the two of you to deal with your conditions and your care needs following this serious crash?
So I didn't even really realize that I was injured at first because of just the intensity of it all, and I was so worried about my wife. Once they were able to take her out of the car, then I realized I had significant injury. We both had some traumatic brain injury. We both had significant injuries everywhere else. That process then we jumped 9 months forward, and I finally go back to work in 9 months. My wife never was able to go back to work. We had 24-hour care in our home for 3 months. We were in the hospital for over a month. Incredible people giving us incredible care. Our community came out, both of our workplaces. My wife worked for the schools. It was amazing the amount of support and encouragement, and also God's healing. But it was a really, really long process.
Well, Steve, what was it like for Sally dealing with your injuries as going down the road of recovery?
She was much more severely injured, many more internal injuries. She has not been able to go back to work since then. She's happily taking care of her grandkids today, so she's doing great. But it was really hard because I would be in a bed. We had hospital beds moved into our home, and I couldn't help her, and she couldn't help me. So it was really quite dramatic. But now, 5, 6 years later, we're incredibly grateful. But it was a really long haul.
One thing that's really important to bring out about Steve and Sally's situation has to do with insurance coverage issues. And so they had lifetime no-fault insurance for their medical expense coverage in relation to their auto accident injuries. Everyone used to have lifetime coverage. Now consumers can buy various amounts of medical expense coverage and even opt out of it entirely. So I know that Steve and Sally racked up quite a bit of medical bills, and that their lifetime no fault certainly was there to take care of those bills. So that was one way in which they were fully covered. But the other thing that happened is that the at-fault driver only had $20,000 of liability insurance to compensate Steve and Sally for their pain, suffering, loss of quality of life, that type of compensation. And so one thing to understand in this situation is that the Whalens were the victims of this horrible, tragic crash. And they were also the victims of a crash involving a driver that didn't have nearly enough insurance. And that's where their decision to buy something called underinsured motorist coverage made a big difference. There was a limit on that. There always is a limit. They wish theirs was maybe a little bit higher than what it could have been, considering the nature of their injuries. But Steve, I don't know if you have any further thoughts on insurance coverage issues and your experience, regarding insurance coverage and your own crash.
Absolutely. And even since then, we've actually upped our insurance since our crash. There's just so many other traumatic things happening in your life that you don't want finances to be the one thing crippling you in the future. We are grateful for the situation. If there is anything additional to this crash, additional surges, they will be covered. But now I'm very thankful that we are able to get some more insurance.
Yeah, and it just brings up so many important aspects of the insurance buying process now in Michigan. You buy the lifetime coverage so that you have all your medical expenses covered, even if you're catastrophically injured. And then you consider buying as much underinsured and uninsured motorist coverage for yourself in the event you're hit by an at-fault driver who doesn't have enough insurance.
Yes.
And so, Steve, the other thing you bring to the table is this experience of also investigating crashes. So now you have like this whole the whole range of experience, right? Being in one and investigating many. And one thing I just wanted to get from you before we end here today is any pointers for our viewers if they ever find themselves in a crash, what to think, what to do, just any common sense pointers.
I've been involved in hundreds of horrible accidents and horrible crashes. First of all, if you have your airbags go off, then there'll be a sense of, you'll smell a burning smell. That doesn't mean your car's on fire. That means the airbags went off. Also, to make sure to assess injuries quickly, to see the status of how everyone's doing before anyone moves. Sometimes people will get out of the car quickly and then they find out they've got an injury, and that could exacerbate that. I think it's really important when you are taking care of yourself, make sure you don't have things to worry about. If you have a traumatic injury, I would always call an attorney. I think it really has helped us tremendously. My kids actually initiated that with us. And make sure you get the right 911 help as soon as possible.
It's Steve, listening to your story, you really had the wherewithal to call and tell them exactly what you needed and what your situation was. And I'm not sure a regular person would be able to do that in the way that you did, but I'm hoping that today's lesson basically can help other people keep their heads on, keep calm like you did, and to potentially save their lives.
Yeah, and that's why I'm so grateful you came out today, Steve. So thanks so much.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Criminal Defense.
Welcome back, Mary Chartier and Takura Nyamfukuza. I heard you had yet another exoneration. How long was your client wrongfully imprisoned?
9 years.
Wow. What happened that led to the conviction, and how did you exonerate him?
Well, he had been wrongfully accused of killing his child. So this was what a lot of people think of as a shaken baby case, although the terminology has changed. It is now more frequently called abusive head trauma. But the government's theory was that he had been alone with the child. The child had a head injury and then ultimately, unfortunately, passed away, and that he was the only one who could have caused this injury to the child. And he was wrongfully convicted, spent 9 years in prison, and then he was released, and we were gearing up for a second trial, and then the prosecutor decided not to move forward.
So tell me a little bit about the experts. How many expert witnesses did the government have in that first trial, and how many did the defendant have?
So the government had 8 experts, and then Takura, how many did the defense have?
Goose egg, big zero.
Right. Zero.
Why the disparity?
Well, his trial lawyer at the time had filed a motion requesting experts. And it's, probably obvious to everyone watching the show that in a case that involves medical and scientific testimony, you need experts to review the documents and help you get ready for trial, and then possibly testify at trial. So he filed a motion asking for the funds for an expert, and the trial court denied his request and said that, well, there were government experts, so he could just use those and ask questions of those experts at trial, and also had commented on the fact that the trial lawyer knew this was going to be a scientific case, but didn't file the motion right away. And I think that ignores the fact that you have to get all the discovery from the government. You've got to go through it. You've got to determine what kind of expert you need in in these abusive head trauma cases. And again, that's the government's terminology that they use, which is wildly prejudicial, just right from the start. But it's not a one size or fits all expert. You've got to determine what sort of expert you need, and that takes time. And usually it takes experts to help you figure out what kind of experts you need. It usually takes medical professionals to help you through the science of what you're reviewing when you look at hundreds of pages of medical records.
So the defense couldn't show a need in a science-based case such as this?
Right, which is crazy. Absolutely crazy, right? I mean, it's just unheard of that you would think, but actually it happens more frequently than you would think.
Yeah, and there's a real bias that the government experts are correct. So why does the defense need them? I mean, we had a case where defense experts, where we were told that they were cumulative to the government experts, and many of them worked with the state or at a hospital and were treating physicians there. I was fortunate enough, Mary, you were there too, to tour the Michigan's MSP, Michigan State Police Lab, where, you guessed it, police officers are working in there. And so, the lack of experts frequently equals a conviction.
And what Shakur said is, 100%. So if you think about that, the government has a number of experts they're putting on. We had retained our own expert, so it wasn't any cost to the state. And then the judge said, oh, well, they're cumulative because the government expert is going to testify to this information. So you can just use their experts. And we're like, well, their experts view it differently than our experts. And ultimately, the Court of Appeals reversed that. But I mean, it's just, there is a real bias against defense experts. And as Takura said, if you think about it, right, the person who is doing the fingerprint analysis for the prosecutor works with the police. The person who is analyzing the DNA works for the police. I mean, there is such a bias that these are government, supposed to be neutral experts, but really they work for the government.
Well, I'm curious, what about the labs that do the testing?
Work for the government. They work for the government. They work for the government. There is, they say it's a neutral lab. It is not a neutral lab. And you see lab scandals popping up all around the country. So for example, Massachusetts had 2. There's actually a Netflix documentary on that called How to Fix a Lab Scandal or Drug Lab Scandal.
So. Yeah.
Right. And they had one lab expert who was actually using some of the drugs that she was supposed to be testing, and then saying that the sample had drugs in it and it didn't. And then you had another person who wasn't doing the testing at all. And in that situation, this person is producing far more lab reports than, her colleagues. And no one thought, well, gee whiz, how is she doing this? Well, we've had situations, they say the lab works for everybody. I've called lab analysts. Some will talk to us, some won't. Most of them assume I work at a prosecutor's office until I tell them I don't, right? I'm a defense lawyer. And then they really want to shut their mouth. And the lab should not be affiliated with a police department. It shouldn't be affiliated with the government in that way at all.
It's essentially the fox guarding the hen house.
Right.
So let's go back to your client. He doesn't have any experts at his criminal trial, and then he's convicted. What happens on appeal?
His first appellate lawyer only raises a sentencing issue and a double jeopardy issue, and no surprise, he loses on appeal, and then he continues in prison for years. The University of Michigan Innocence Project then gets involved because innocence projects around the country are now getting involved in, again, the language that most people probably are familiar with is shaken baby syndrome cases. So a lot of innocence projects are getting involved in this because the science is not sound at all. And there's a lot of discrepancy over the science. And they've exonerated a lot of people based on this flawed science. They get involved. It is a fascinating appellate history, which we're actually going to be going into more on our podcast called Constitutional Defenders, if anyone wants to listen. And it involves hearings and experts. Ultimately, the client gets a new trial, and then we get involved. We fight it out for a little less than 2 years and convince the prosecutor not to move forward.
Wow. And how hard is it to defend cases where a person's been accused of abusive head trauma or shaken baby syndrome?
Oh, it's very difficult. People hear that, they believe it, and the government can tug at the heartstrings in cases like this in ways that they can't with other cases. So, in a lot of cases where the science is wrong, people have been convicted and some even sent to death row. So fortunately in Michigan, we don't have that.
And how do juries tend to react when they hear scientific evidence, especially when that evidence is coming from the prosecutor or the government?
They believe the government. I mean, especially you can see what happened in this case. There are no defense experts. Once the defense is able to get experts, they're able to show that the science that was the foundation of the conviction is totally flawed. And then you have someone who's exonerated. But they tend to believe the government experts. And that's why it's so important for the defense to have their own independent experts to be able to fight these cases, to make sure there are no more wrongful convictions.
Well, Marion Takura, congratulations again to you, and especially to your client who had to fight so hard for his freedom.
Thank you. We're thrilled with the result, and then on to the next exoneration.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC.
Thank you for watching our show. Look for another great episode next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.